Lord Thomas, you had a question.
Yes, I've been interested in the reaction to your resignations.
Yes.
Carrie Lamb said that foreign judges were only asked to swear to uphold the basic law, bear allegiance to Hong Kong and serve its people. I quote, "We've never said or required them to support the executive branch or endorse its policies and measures." The news was met with widespread dismay. The Hong Kong Bar Association, the Law Society of Hong Kong, expressed deep regret. Senior Counsel and Executive Council member Ronnie Tung wished the pair had shown more backbone to resist pressure from politicians, and former Chief Executive C.Y. Leung, meanwhile, did not hold back, calling the judge's departure a permanent stain on Britain's judicial independence. So that's a fairly strong reaction. I'd be interested in your comments upon it.
Well, can I say first it was a matter of deep regret to me as well, that we felt we had to resign. In answer to the first point you raised about the scope, as it were, of our responsibilities, when the national security law came into force in the summer of 2020, I discussed the way forward with the Lord Chancellor and the Foreign Secretary. All three were involved because our participation in Hong Kong was to implement an agreement that the government, particularly the Lord Chancellor, entered into in 1997, and which Lord Faulkner renewed in 2004, under which Britain undertook to provide judges to the Court of Final Appeal in Hong Kong. And the operation of the agreement obviously depended on two things. One was the government's continued willingness to operate it, and secondly, the Supreme Court's continued willingness to provide judges to serve under it. And since effectively either side, the government or the judiciary, could pull the rug on it, I and the two ministers thought that the best way forward was for us to jointly monitor what was going on in Hong Kong and have discussions of the implications periodically to decide where we stood. And we also agreed on criteria that we wanted to have in mind in monitoring what was developing. And it was actually me who suggested, or insisted, that we have a criterion which wasn't to do with the courts, but was to do with society more generally. Because I felt that if, for example, to take an example, the courts in South Africa continued perfectly to apply the rule of law during the apartheid era. But I wouldn't have wanted any Supreme Court justice to have been serving on the courts there in that period, because the society was one in which our judges would just bring discredit on themselves if they manned one of the major institutions of government in that society. And I thought the same was we should at least guard against that possibility in relation to Hong Kong as well. And so what happened thereafter was we received briefings prepared by the Foreign Office on what was happening, and we assessed what was going on against the criteria and formed a judgment as to whether we should carry on working there or not. And there was, as everybody knows, there's been a gradual erosion in political freedom and consequently in freedom of speech in Hong Kong. which became progressively and noticeably, I felt, worse in the latter part of last year and the early part of this year. The courts themselves were continuing to operate in accordance with rule of law values, although they were under pressure. And it has to be said that one can't completely divorce what was going on in the courts from what was going on outside the courts, because essentially what was going on outside the courts had two components. One was the use of powers conferred by the national security law to close down businesses and seize property. The other was the arrest of people on charges of having violated either the national security law or laws passed during the period of British rule, concerned with sedition, for example. And once they were arrested, they were then being refused bail, essentially because of the gravity of the charge. But the consequence of, is that, for example, if you were a shopkeeper who had posted on social media your criticism of the absence of a vaccination program in Hong Kong, for example, then you would find yourself arrested on a charge of sedition, refused bail, and you're then liable to be detained in prison for the best part of a year, perhaps, before you come to trial. So, in the light of the crackdown on freedoms to which we, on the Supreme Court, and indeed in our society, are committed, that a stage was reached when we were in agreement that the time had come for us to withdraw. Now, we were not, I was not under pressure from politicians. That's a mistaken reading. There were some things published in Hong Kong which may have encouraged that misunderstanding. But I actually sought the meeting at which we took a decision because of my own concerns, and found that ministers were of the same view. And so the final point you mentioned was judicial independence. Well, there was no compromise of our judicial independence. It would have been rich irony if there had been, but there was none. The discussions I had with ministers arrived at a consensus, and I wasn't being dragged out of Hong Kong, as it were. I felt the time had come when we had to call it a day in the interests of the values that we represent. I have to say, it's a matter of great regret. I was very fond of Hong Kong. The people were unfailingly friendly and courteous. I've the highest regard for my former colleagues on the Court of Final Appeal, and I'm very saddened that matters ended this way, but there it is.
So you're very clear that it was your decision and not any political influence either from this government or from the Hong Kong government which led to your resignation.
That's right. The government having reached the same view, that they thought it was time for the government to withdraw from the agreement, that would, in any event, have compelled us to resign, because we could hardly go on sitting in China on a Chinese court if when the taxpayer is paying our salary. If the government wanted to withdraw from the agreement, But as I say, the continuation of the arrangement required the agreement of both the government and the court and me as the head of the Supreme Court. And we both took the view that the time had come to call an end to it.
Does the continuing presence of 6 former Supreme Court justices and justices from Canada and from Australia, does that cause you concern?
No, it doesn't. I think it's a matter for them. They are retired. They have to make their own decision. They're not in the same position, I think, as a serving judge exercising public power in the UK.
I take it you're not aware of any pressure from the Hong Kong government on them to stay?
No, certainly not. I have, in fact, been in discussion with them, and I'm sure it would have been mentioned. So, no.
Thank you very much. Thank you.
Can I ask,
Yes,
if you hadn't been paid as public servants, if you are not chairman and deputy chairman of the Supreme Court, then the situation would have been different?
well, we'd have been in the same boat as just say I'd retired, for example, I'd have been in the same boat as those who have retired.
That's the break point for you. The break point was that you were serving on the Supreme Court at the moment, not the principle of collaborating with the Chinese regime in Hong Kong.
I personally would have felt the time had come to leave, in any event. If even if I had retired, I would have felt the time had come. But because I am the President of the Supreme Court, my primary concern had to be the reputation of the Supreme Court and behaving, and that institution behaving as it ought to in our Constitution. And so whatever my own views happened to coincide, but I'd formed a view that it was no longer in the interests of the Supreme Court. In fact, it was damaging to the interests of the Supreme Court and the respect in which it's held for us to continue.
And if the other 6 seek your advice, what would you say?
Well, I would say to them, it's a matter for them. I wouldn't. I mean, we're talking about extremely experienced, very, very experienced judges. I mean, two of my predecessors, the Chief Justice, the former Chief Justice of Canada, for whom I have the utmost respect, and two former Chief Justices of Australia, and another very senior Australian judge, whom I also have great respect. So, and former colleagues on the Supreme Court. Those who weren't president were members of the court and were colleagues and remain friends. I don't think they need my advice, but it's their choice what to do.
If I could just add, if I may, I also tendered my resignation at this time, and I think it is of central importance that Robert and I were members of the UK Supreme Court with public duties in this country. There have been 2 sides to this debate throughout, and the matter has been finely balanced for quite a long time. I mean, clearly, the concerns about the removal of people's freedoms in Hong Kong has been weighing very heavily on Robert and me, and no doubt our colleagues who've remained. But the other side of the coin is an equally real concern that we should do what we could in difficult circumstances to support the people of Hong Kong and support the able judges who are trying to uphold the rule of law in the way that we've traditionally understood it in this country, and they continue to understand it that way. So I think it's a very finely balanced decision, and I certainly wouldn't treat my resignation as any implicit or explicit criticism of those who've reached a different view.
Yes.
Well, a couple of supplementaries. Lord Howell and Lord Faulkner. Do you want to come in, Lord Howell? Lord Faulkner.
I've got particular views on this. I don't want to. I mean, you know what they are.
Do.
And I completely accept that you, as the two office holders, are in a different position from the ex-members of the Supreme Court, and it is their decision. You, Lord Reid said in his statement, "I have concluded in agreement with the government that the judges of the Supreme Court cannot continue to sit in Hong Kong without appearing to endorse an administration which has departed from values of political freedom and freedom of expression to which the justices of the Supreme Court are deeply committed," with which I agree, that statement. Presumably the 6 former justices of the UK Supreme Court are equally committed to those values.
Yes.
And without in any way being critical of them, it must be better for the UK. And it is their decision in a way that's different from you two. They should resign on the basis that they would be sending the message that the justices of the Supreme Court, past and present, are deeply committed to those values.
Well, it isn't for me to speak on their behalf.
No.
You should understand that they have served on the court in Hong Kong far longer than Patrick or I. Lord Hoffman, for example, has served on it since the 1997 withdrawal. What's that? 25 years. And some of the others for not much less than that. There are very strong personal ties of friendship to the judges there. I think Lord Thomas mentioned the perception in Hong Kong that our withdrawal is a betrayal, and that if you like, we were the canaries in the coal mine, we've disappeared at the first whiff of gas, and we haven't stayed there to help them out, and they may be more vulnerable as a result of our leaving. All of that is true, and I think our colleagues, out of our colleagues' feelings of loyalty to their colleagues on the Hong Kong court and to the people of Hong Kong, are probably a weighty factor in their thinking.
Questions? Well, I think